It's my pleasure to be here and to keep the presentation about my topic, the role, powers, and the challenges of the environmental protection authority. My duties is to compare and to sum up the practice of the four countries. And I'd like to thank you as well to my colleagues who made their studies available to me. First of all, Ms. Joanna Narodowska and Maciej Duda. They came from Poland, from the university. And Antoni Frič, who is the head of the Department of Legal Affairs of the Czech Environmental Ministry. And Jenčo, who is an expert of this topic from Slovakia. And my first slide is about what is the environmental inspection as a regulatory tool. As you can see on the slide, according to the studies, the inspection is a systematic assessment, a supervisory and enforcement tool that evaluates that the project developers or in general the environment users' compliance with the rules of environmental laws, regulations, standards, and permits. And its oversight is essential for mitigating environmental risk, fostering sustainable development, and safeguarding public health interest and the protection of the whole natural ecosystem. And in the first time, you can see the first difference among us, because the forest protection is the part of the duties of the Czech environmental inspectorates, which is not general. In other countries, it appears only in the field of nature conservation of mostly the protected forests. I'd like to say only some words about the legal background and the organizational structure of our countries, because last day Professor Szilágyi kept an excellent presentation about our constitutions. So I'd like to highlight only some aspects. For example, the Polish and the Hungarian studies referred to our constitution, that environmental protection and about the sustainable development, both in legislative branch and both in the executive branch. But the latter was developed in Hungary by the Constitutional Court. And it's very important when we speak about the organizational structure of the inspectorates currently or in the future. And then I'd like to say some words about the acts in the legal hierarchy. It's interesting, all of our countries, there are differences between the concept of nature and the environment. There are two acts, and the environmental protection is a broader concept than nature conservation. Latter is the part of legal environmental protection. It's also important that in the inspectorates, the inspections and the inspectorates itself were established in 1991 in all countries after the collapse of the socialist regimes. And I have some slides about the organizational structure, but I don't like to repeat the former presentation, which was also excellent. So I'd like to say only that the authors mentioned the positives of these structures. Everybody emphasized that the territorial inspectorates, or in Hungary, the government office can respond more rapidly in an accident or an environmental incident or as a serious damage or danger, and they have specialized knowledge of local environment. Why the central administration can or could ensures the consistency in the inspection methodologies and in legal interpretation, and they can enforce standards across all regions and territories. But there are some differences. As we heard, in some countries, the central administration coordinates the complex cases, I mean the environmental impact assessments and IPPC permits. And naturally, there are interagency relationships with other ministries, regional and municipal offices, and local governments as well. For example, in Poland, the provincial inspector may entrust the district authorities with handling of matters, including the issuance of an administrative decision as well. And this so-called delegation of administrative tasks and this kind of agreements are very common in Poland. And in the field of criminal law, the authorities cooperate with the police and the public prosecutor offices as well. They can file criminal charges and participate in criminal proceedings as an expert. But there are some differences among the countries. For example, in Slovakia, in the case of criminal offenses, the authority doesn't conduct the administrative sanctioning proceedings, but take the case into the criminal authorities. And we have the same problem in Slovakia and in Hungary, and thanks to the mentioned ne bis in idem principle, because, for example, in Hungary, the unlawful conduct are mostly the same, both in the field of an administrative offense and in the field of the criminal offense, and it's especially in the field of nature conservation. And in that case, we have to suspend our administrative proceedings till the end of the criminal proceedings, and we are bound to the decision of the court. If the court find our client guilty or has acquitted him or her, then an administrative sanction, I mean the fine and the prohibition from the activity cannot be applied as an administrative sanction. And there's another additional rights in Poland. For example, they participate in the proceedings with the same right as a public prosecutor in criminal offenses, and they can lodge a complaint with the administrative court. And as we heard earlier, our authorities are member the National Environmental Security Task Force in Hungary and in Slovakia as well, and the member of the Impact Envy Crime platform. And luckily, it's well functioned in Hungary, although they suffer from personal shortage. But unluckily, it doesn't say about the Slovakian practice. And I'd like to say something that in Hungary we try to solve the ne bis in idem principle. And in this year, there was an amendment in the field of legal persons, because in Hungary, the criminal measures can apply not only natural persons, but only legal persons as well. And according to this amendment, the application of a criminal measure may be omitted, or the amount of the fine may be reduced if a legal disadvantage has already been applied in a final decision of an administrative authority, or vice versa from the administrative court. But the question is that whether this will be enough or appropriate. solution because there are lots of problems with this question. For example, the Slovakian or Slovak author pointed out that the police almost exclusively use the expert opinions to determine the exact scale of the damage, which takes a very long time, and it complicates the whole procedure. And I'd like to add that in addition, at least in Hungary, the administrative fines can be imposed and enforced more quickly. And it has a greater deterrent effect due to the amounts of the fines that can be imposed. So, as you see, we prefer the administrative fines instead of criminal offenses. Yes, the next slide is about another topic, which is about the powers of individual inspections. And we have almost the same rights, but in some with some small differences. And you can see on the slide that the inspectors has a right to enter into buildings, transport vehicles, and other premises to take immediately measures if need to halt or rectify an activity, or they can use a sanction, which can be different in our countries. For example, in Slovakia, there's differences between the natural person and the legal entities. And you can see other rights, for example, require submission of documents and other materials, assess environmental impacts of the activities, to cite specimens in the field of nature conservation, for example. And in Poland, in the case of more serious conducts which harmful to the environment, they have an even broader range of powers. And in Slovakia, the nature protection has a stricter procedural framework in an inspection. And in Hungary, the nature guards who are the employees of the National Park Directorates as additional rights, they can use restraining measures as well. And the Slovak author mentioned that the financial penalties which is imposed by the authority is the revenue of an environmental fund with a mandate to finally support environmental issues or protections. And in Hungary, only the compensation qualifies as such, but as you heard yesterday, it's only the part. Also, thank you, the nebis in idem principle. Okay. The next slide is about the types of the inspections. In our country, there are 3 different types of inspection. The first is the routine or scheduled monitoring inspection, which based on annual inspection plans. And all of us mentioned the IPPC rules, which directly mandated to conduct regular inspections from 1 to 3 years, and it's based on risk assessment. The other is the targeted enforcement inspections, for example, for previously identified violations and for potential significant environmental impact. And further is the emergency response or unscheduled inspections. Then, as you can see on the slide, an environmental incident poses imminent threat to ecological system or to the public health. And naturally, the public or the NGOs has a formal right to alert these incidents, and as well the local or other authorities. But these inspections also may be based on the own perception of the authorities, for example, when they renew or modify an existing permit. The Slovak author mentioned in their study that the Water Protection Division maintains a whole week emergency readiness. In Hungary, the whole authority fulfill this readiness. And all of us, the inspection countries, reflects the EU standards, and a report is prepared on the inspection or after it with the findings and the evidences of the inspection. And you can see also in the slide that which kind of possibilities has the client if against the findings of this report. For example, in the Czech Republic, the client has a right to file an objection to the superior of the inspecting officer. And but in Hungary, he can only make a statement, and he can appeal to the court against the final decision. And this is the same in Slovakia, but the findings may be subject and appeal first, and then he could turn to the court. And naturally, the decisions may also be subject to a prosecutor's review. Okay, the next slide is about our challenges and shortcomings. All of us mentioned the limited financial resources, and for example, the state as an employer is unable to offer comparable salaries. And naturally, there are shortages of technical resources, for example, in vehicles, in using limited number of drones, and especially for equipment for laboratory analysis. And there is also a persistent shortage of inspectors. Because their duties or they need not only professional knowledge but also legal knowledge. And for example, in Hungary, the same people carries out the inspectors who permit who make with permissions, which takes capacity away. And in addition, there's an expectation that at least 2 persons take part in the inspection, which is important in one aspect, for example, for transparency, but it exacerbates the problem. And the authors mentioned among the legal barriers the overlapping competencies among the authorities. And while in other fields there are insufficient competencies, for example, Czechia mentioned the limited jurisdiction in forest protection, while in other field, such, for example, market surveillance, take away capacity for the work from the work of the inspectors. They mentioned the complexity and fragmentation of the legal framework, the inconsistent decision-making practices. But in Hungary, we have less experience in this field because the appeal is relatively new field in Hungary. And they mentioned the length of administrative procedure and the prolonged duration of the administrative process. And in Hungary, the solution is that, according to our acts, that if the authority exceeds twice the administrative deadlines, it no can longer apply sanctions. We can only identify the violation of the law. Poland mentioned that bringing and supporting indictments are positive development, but in practice their application is limited only in certain cases. And our colleagues mentioned the insufficient upper limits of fines, which weaken the deterrent effect. And for example, in Hungary, in the field of environmental protection, the legislation has been modified recently. And in the field of nature conservation, we are planning to increase the value of the protected species. And our find is mostly based on this value. And we hope that it will be enough, not only for higher administrative fines, but also for higher punishment from the judges in the criminal process. And our colleagues mentioned generally the whole challenges in enforcing the decisions, which undermine over-regulatory effectiveness, and the insufficient modernization was mentioned by Slovakia. And I'm sorry, but there's a last slide, which is about the future perspectives. And in general, there are parallel with the challenges and the shortcomings. It's essential to clear and precisely define the competencies among the authorities and to issue guidelines for the legal practice. And for example, in the field of digital tools, as our state minister mentioned yesterday, it's necessary to invest in modern technologies, including use of digital tools, artificial intelligence, and so on. And there are some reforms, or maybe not practically, but rather only in our mind in the field of the organization structure. In Hungary, as we heard, the appeal against our decisions is available again, because it was abolished some years ago, but it's only a limited scope only for complex cases and related fines and prohibitions. And we have a plan to restructure and develop the whole laboratory system in Hungary, not only in the field of environmental protection, but also in the field of, for example, the public health and the food chain safety. Among the plans in Poland, there was a plan to create a singular authority in the form of an agency, or with the merge of the chief inspectorate with the provincial inspectorates, and the opposite was in the Czech Republic, where was a consideration regarding the merge to take it to a level body in the country. And in the Slovak Republic, there was a suggestion to establish two separate structures, one for permitting and one for inspecting authorities. And thank you for your kind attention and your patience.
First of all, ladies and gentlemen, thank you for a great opportunity to be here. So I'm glad. And it's a pleasure to speak today about legal challenges faced by the Czech Environmental Inspectorate, or CEI, an agency which is a really important authority of environmental enforcement in my country. The CEI is quite a unique body because externally it functions as a single national-wide administrative authority, but internally it operates through 10 territorial inspectorates and central headquarters. This dual nature was designed to balance national consistency with regional responsiveness. So main advantage is quick reaction and maybe knowledge of the territory of inspectors. So, however, in daily operation, this legal construction has revealed certain practical problems. Because territorial inspectorates handle most inspections and sanctioning work, while headquarters has only methodological and supervisory control, there's sometimes questions who exactly decides what and who is exactly responsible for. We have seen, for example, differences in interpretations of similar environmental violations or variations in the levels of fines. In short, procedural uniformity has not always been perfectly achieved. For this reason, they have been just theoretical discussions about transforming CEA into two-tier authority, like, for example, Czech Trade Inspection Authority. It's the same model, with the regional inspectorates as the first instance bodies and headquarters as an internal appellate body. Such reform would strengthen legal certainty and professional coherence, but it would require legislative changes, which are not on the table, so it's just only in theory. Without these changes, is necessity stronger methodological guidance, digitalization, and use of shared information system. Maybe the headquarters should provide more legal support and instrument for regular inspectors who are experts in environment but not lawyers, and law is right now really difficult for them. Second question I want to highlight is the recurring problem of overlapping competencies. Environmental law in Czech Republic is highly fragmented. For example, in nature and landscape protection, inspection and sanctioning powers are distributed among 6 authorities: CEI, regional authorities, municipal authorities, national park administrations, protected areas bodies, and also nature guards. So these fragmentations sometimes leads, in one hand, to parallel proceedings, breaking nebis in idem principle, or in the other hand, to gaps in enforcement. So eliminating such conflicts require a combination of tools. Maybe clearer statutory division of competencies, more binding methodological instructions, sharing information between agencies, maybe in one digital system, it will be helpful. Or sharing inspection planning. And important is also human element, just cooperation between bodies. Maybe concentrating powers in hands of only one authority could be also the way. So this is my answers. Thank you for the opportunity to participate in such a beautiful event. It's both pleasure and honor to present in front of distinguished legal authorities. Thank you very much. So the first question was about the enforcement corps. That's the term that I use for nature guard, water guard, and actually because that's the substantive amount of their work to enforce particular legal acts. And in Slovakia we have basically 6. enforcement corps of guards. 3 are under the governance of the Ministry of Environment. That would be Nature Guard, Water Guard, and Fisheries Guard. Each one of these guards is governed by their own separate act, and they are only allowed to enforce this act, nothing else. And under the Ministry of Agriculture, there are 3 other guards. That would be Field Guard, Forestry Guard, and Game Hunting Guard. So, for example, if a member of Nature Guard is in a forest that's in the protected area, he is only allowed to enforce the Nature and Landscape Protection Act, not the Forestry Act. And with Andrea, we talked that we both have a special place in our heart for nature protection. So I will try to elaborate more on the Nature Guard, which is also a good example how these 2 Nature Guard and Slovak Environmental Inspectorate can cooperate and have fruitful results. So historically, nature protection was part of historical monument protection. And back then, in that time, there were voluntary conservators and voluntary reporters. And that's basically the source where the establishment of Nature Guard per se comes from. So it must be understood that Nature Guard is not like a separate structure. It consists rather of individual natural persons that are designated to enforce certain law. They must pass a certain examination, they take a vow, and they can basically enforce their powers. So it's about the individual members. There is no hierarchy within the structure. However, this was a legal ground for establishment of law enforcement park rangers in Slovakia, who are regular professionals and employees of the management bodies to the protected areas. However, when I used to work for the Slovak Environmental Inspectorate, we developed a special information tool, like information system, that could enable the communication between Slovak Environmental Inspectorate and the inspectors and members of the Nature Guard, because in this particular field, Slovak Environmental Inspectorate is also able to impose environmental legal liability towards natural persons. In other areas, it's usually against legal entities. So let's say if the Slovak Environmental Inspectorate got a complaint and there were no available inspectors to go there, they could put a demand within the information system, and the member of the Nature Guard could see a notification, and it was like, okay, I can go there, it's really close to my place, and I can check it, maybe monitor that area, maybe gather more evidence, and send it back to the Environmental Inspectorate, and they can decide whether it will be solved just by the member of the Nature Guard, if it was some type of petty crime or petty offense, let's say, or if it should be dealt with the Environmental Inspectorate. However, now the system is shut down, it isn't working, which is really thanks to our current government. And if I have enough time, or if that's enough.
I think it's enough.
Yeah. Okay, so there is another question about the concept for combating environmental illegal activities. That was the result of a tension between Ministry of Interior in the Slovak Republic and the Ministry of Environment of the Slovak Republic. I believe in 2020, a Ministry of Interior and Environmental Criminal Police came with an action plan on combating environmental illegal activities. And the Ministry of Environment was like, this is not going to help us. There are more greater problems that need to be solved first. So we need a strategy material to where do we want to go in few years. Not like just to have this action plan that basically just establish certain working parties, working groups, because we were like, we have these groups already here and they are not working. This is not going to help us. So the result was that the Ministry of Environment basically made this concept as a greater strategic material and pay credit where credit's due. Biggie, who was one of the main authors of the concept. So we basically tried to summarize all the problems that had already been mentioned here during these 2 days. We focused on clear definition of competencies, or rather say jurisdiction of very many different bodies and authorities that are entitled to deal with the enforcement of environmental legislation. We also tried to focus on rather more effective supervision or supervisory system We also try to focus more on reparatory function of imposing environmental legal liability via different types of corrective measures. And last but not least, we also focus on better management of public finance, because we must say, or at least that I feel it, that in Slovakia, many actions are considered criminal offense, and they must be dealt with police, prosecutors, judges. And the severity of such actions is not that high, and it should and could be effectively dealt with administrative bodies, which is basically have to pay for the inspector or the member of the guard. So those are the 4 pillars that we try to make strategic goal and operative goals within the concept, to focus on all the problems that we just mentioned here during this conference. Thank you very much. Thank you for your attention.
Hello, everyone. Thank you very much for your questions. Ladies and gentlemen, first of all, I would like to thank the organizers of the conference for inviting us to participate. It's the first time we are attending the JAEL conference, so we are very happy to join this distinguished group, even though we have to travel more than 1,000 kilometers from our city to Budapest. Probably is the longest journey of the all conference participants. The moderator asked us 2 questions about the powers of Polish Inspectorate for Environmental Protection as a law enforcement agency, and about the achievements of green criminology in the field of environmental crimes. We are running out of time, so I will try to do it briefly. As regards to the Inspectorate of Environmental Protection, it actually gained law enforcement power in 2018. This is a rather unique solution and should be viewed positively. In theory, the Inspectorate has the power to conduct preliminary investigation and bring charges against for environmental crimes before the courts. However, the list of the crimes for which the Inspectorate can implement its powers has been significantly reduced, and refers only to the 8 most serious crimes listed in Polish Criminal Code. The theory looks promising, but and the legislator intention should be assessed positively. However, in practice, these crimes are committed rather seldom, and that leaves the vast majority of the crimes against environment not covered by the criminal code outside the scope of the Inspectorate's powers. In addition, the lack of the parallel amendment to the Polish Code of Criminal Procedure, especially Article 312, means that the Inspectorate does not have the powers to conduct investigative and operational activities. As a result, it's practically impossible to effectively conduct criminal proceedings in case of environmental crimes. Therefore, it's necessary to amend criminal procedure and give the Inspectorate the same power as the police. When assessing the effectiveness of Polish environmental protection authorities, it is also necessary to mention such prosaic problems as you mentioned, the staff, the material, and the financial shortages. This results in a reduction of the number of the inspection and the leaves of the most experienced inspectors from the state service to the institution, to the private entities. The phenomenon known as competence chaos is also significant. Too many entities, similar to the Czechia in Slovakia, involved in the environmental management process cause their competence sometimes overlap and sometimes intersect. In the situation where the given area of social activity can be controlled by different entities, all of them may initiate the control at the same time, obstructing the normal functioning of the entity, or contrary. None of them none of the institution undertakes control, hoping that another service or body will deal with this matter. That raises the question whether Polish solutions in the field of combating environmental crime can serve as a model for other V4 or European Union countries. Frankly speaking, probably not. At this moment, because of the procedural obstacles, our system is far insufficient. Therefore, it requires further improvements. And about the achievements of the green criminology, I think the Joanna will tell more and better, because she has you mentioned, she is a very important person in green criminology society. The first season.
Ladies and gentlemen, first of all, thank you for this great presentation, and thank you for invitation and opportunity to tell you more about green criminology, because I'm not sure if you're familiar, but it's very close as towards green means environment, and criminology, dealing with the really spectrum of the crimes. So maybe a few words about the green criminology group, who we are, and of course I'd like to invite you. So I hope you will be curious to get more information and maybe join to our group, who we are. So Green Criminology Working Group is a division in the structure of European Society of Criminology and was formally established in 2024, but it's operating in the scientific community for almost 20 years. So quite long. We are kind of divided into the section. One, the really strong one, it's European section. Unfortunately, most of the members are from they are not from Central Europe. That's why we don't know really much about what's going on in the environmental research in this part of Europe. It's Denmark, England, Sweden, Norway, and Poland. So I met them 10 years ago in Sarajevo, and that was the beginning of green criminology in Poland, I can say. And we've got a kind of international division, and most of them, they are from Anglo-Saxon countries, especially United States. I think they are at this moment the best in green criminology, and they give the trends, the global trends. Next week we are going exactly to Washington DC, and we've got American meetings. It's the American Congress of Criminologists in the international dimension. What we are doing as a group, so as I mentioned, most of us, we are the scientists, but not only. And this is kind of the scientific platform for exchange, international cooperation, and implementation of research project on broadly understand environmental crime. We understand environmental crime very, very, I could say, broadly. So it's all the acts that are directed against the environment as a ecosystem. So it's environmental victim, human victim, and also non-human victims, which are plants and animals. What is very important, green criminology broadens the traditional understanding of crimes, and also take into the account legal practices that cause significant environmental damage. I could say more, so, but I know that there is not much time. So maybe I will tell a few things about current direction, what we are doing in the global scale. As I mentioned, we are international scientists, and not all of us are the lawyers. So I could say that the legal framework is just the background. So we pay far more attention to the genesis. So why some phenomena happen. Then we try to identify the forms of illegal acts or legal acts, but that damage the environment, and we create the policy. Traditional, the spectrum is as I said, like traditional crimes that are directed to the environment, but also new forms like renewable energy, for example, mineral crime, land-related crime, water crime, and much, much more. Our last task, I would say, we were called as an expert in United Nations, UNODC, so it's United Nations Office Drug and Crime, and we took part in creating and looking. Our mandate was given by the resolution 12.4 to look for the loopholes in the system, in the international scale, and it also give the basic. It was we were doing it the whole summer. Give the basis, the acts we were talking about yesterday. So that was the foundation. So I hope there will be opportunity to say more in the backyard. Thank you.
Thank you for your answers. And as I checked, we have time for a cross-cutting questions for our final discussion. And my question is, which elements of your national approach could serve as an inspiration for more harmonized V4 or EU framework? And it's your floors. The floor is yours.
If I may start, should I go there or can you hear me properly? Okay. Yeah. Oh, it's working. So if I may start, I would probably relate my answer to already mentioned concept for battling illegal environmental activities. That concept was unfortunately shut down, but we were able to implement some of the ideas already introduced in the strategic material within the new Air Protection Act in Slovakia, which was adopted in 2023. And some of the measures that we introduced within the act was simplification of the supervision that I already pointed out was very lengthy, and also some other measures to more support the reparation or voluntary fulfillment and enforcement of the act, like a waiver, partial waiver of the financial sanction if the sanction is paid within the due time. So that's something that really something that you can really take from Slovakia, and also the use of modern technologies, information system, digitalization. However, as I said, it's declining in these current times, but it's something that's probably very, very useful. Thank you.
Thank you. I would like to say something similar like your last mention, because I can mention the proactive use of technologies like drones, samples, remote sensing, and also we have first troll satellite in universe, and we can use it. So it will be maybe interesting results from the satellite. And also we can provide AI tools like legal tools for regular inspector to improve their thoughts in legal systems. So it could be also helping.
Thank you very much. I think about what kind of structure of environmental protection authorities is better. If it should be one central institution, let's call it National Environmental Protection Agency. Because as you said, both in Poland, in Czech Republic, Slovakia, we have many authorities. Of course, in Eastern European countries, Central European countries, we have some we are suspicious with the central organizations after the communist era. But one central authority is the opportunity to avoid the overlapping and intersection of the duties and the competences of the organization.
I would just add that what we are doing research. So when we were preparing our article, I made some interviews with all the representatives of our authorities who deal with the environmental system, and they said generally that what is really needed, required, it's just one authority that will be responsible for all the issues regarding environment. And that's the solution, in my opinion.